because we are absolutely delighted to have one of the country's leading academics in the field of marriage law and matrimonial law. She has a chair in Exeter and has written extensively on this subject. I think in a moment she'll be loading up her PowerPoint slides to accompany her presentation. But would you please join with me in giving a very warm, albeit an entirely inaudible welcome to our distinguished first speaker this morning, Professor Rebecca Probert.
Great, thank you. So as Mark said, I'm going to be talking about the evolution of the current law of marriage. Now, the laws governing how couples can get married obviously have very deep roots, intertwined as they are with religious, cultural, social, political history. And in this paper, I'm going to be focusing on more recent history and try to distill the findings of my new monograph of how marriage law has evolved from 1836 to the present day. I'll look first at the making of the 1836 Act and how even at the time it was enacted, it was not seen as a satisfactory solution. I'm then going to outline the changes that were made in the 1850s and the 1890s and briefly touch on the process of consolidation that resulted in the Marriage Act 1949. Now, I'm taking 1836 as my starting point because the structure of the modern law of marriage was established by the Marriage Act 1836, although I will be delving briefly into the pre-1836 law. The 1836 Act has always been seen as an important liberalising measure in recognising the religious diversity of 19th century England and Wales. It did so by allowing an alternative means by which couples could marry if they did not wish to marry according to the rites of the Church of England. And I phrase that quite deliberately for reasons that will become clear, because what the Act did not do was as important as what it did do. As I'll show, many of the problems with the current law can be traced back to the making of the 1836 Act. So to understand the design of the Marriage Act 1836, it's necessary to look at the campaign for reform that preceded it, the constraints within which those proposing reform were operating, and the political agenda that it was made to serve. As I'll show, three key factors shaped the form of the Marriage Act. The first was the way in which the campaign for reform was framed. Protestant dissenters were seeking relief from compulsory conformity rather than recognition of existing rights. While there was a separate campaign in relation to Catholic marriages, which did focus on the recognition of existing marriages, this was later and less influential. The second factor was the continuing concern about the risk of clandestine marriages. Any proposals for reform of the law had to provide at least the same safeguards as the existing processes for getting married in the Church of England. And the third was the desire of the Whig government to implement the new poor law across the entirety of England and Wales. Now, I'm going to start with the second of these factors because it relates to the law against which Protestant dissenters were campaigning. The Clandestine Marriages Act of 1753 had given force to the canon law of the established church by enshrining its requirements in statute and invalidating marriages that did not comply with them. All weddings, save those of Quakers and Jews, had to be preceded by the calling of banns or obtaining a license from the ecclesiastical authorities, be solemnized in an Anglican church or chapel, and be duly recorded in its registers. While the 1810s and early 1820s had seen debate about the precise formalities that should be required and the consequences of non-compliance, matters had been settled by the Marriage Act of 1823. This had reenacted the requirements set out in the 1753 Act, but with the reassuring proviso that only a knowing and willful failure to comply with them would render a marriage void. With these matters so recently resolved, it's unsurprising that Parliament wished to ensure that any new alternative would not be any less tightly regulated. Any new scheme would have to ensure that weddings could not take place in secret and that there would be an opportunity for objections to the marriage to be made by the parents or guardians of minors, or by anyone who knew of an impediment to the marriage. In other words, there had to be some system of advance notice. And no one really disagreed with these safeguards. All accepted the need for advance notice and the need for marriages to be registered. The only question was who would be responsible for these elements. The challenge was to find a process that was sufficiently independent of the existing Anglican structures to satisfy both dissenters and Anglicans. A lot of the proposals for reform assumed that even if a wedding might take place in a dissenting place of worship, banns would still be called in the Anglican Church and the wedding recorded in its registers, which is really a solution that pleased nobody. So both sufficiently independent and sufficiently rigorous to assuage any concerns about a new law being used as a cloak for clandestinity. So this brings us on to what reformers were actually asking for. The campaign for reform was led by the Unitarians, who argued that the requirement to marry according to the rites of the Church of England was a violation of their religious beliefs, since it compelled them to participate in devotions addressed to the Father, Son, and Holy Ghost. Their initial proposal was that they should continue to marry in the Anglican Church, but be permitted to omit any references to the Trinity in so doing. However, the Church of England was understandably opposed to the idea of couples being able to simply request changes to its liturgy, and the focus of reform shifted to devising an alternative to the Anglican rite. Now, framing the principle at stake as being the right to marry in a way that did not violate one's conscience was significant for a number of reasons. It was a principle that reformers could argue had already been accepted in relation to Quakers and Jews. But it was essentially a negative principle, a right not to be compelled to do something, rather than a positive right to do something. It was not the same as a principle that non-Anglican religious groups should be able to conduct weddings. Indeed, it prioritized finding an alternative above the form of that alternative. With numerous bills coming before Parliament in the 1820s, with very different options for reform, it sometimes seemed as if any alternative would satisfy the reformers. Equally, it sometimes seemed as if no alternative would satisfy those who were concerned about the risk of clandestine marriages. The existing exemptions for Jews and Quakers, it should be noted, were both an ambiguous and an unhelpful precedent. As I mentioned, the 1753 and 1823 Acts had exempted Quakers and Jews, but they had said nothing about how their marriages were to be regulated, or even whether they were valid. While it had been resolved that the validity of Jewish marriages was to be determined by the application of Jewish law, the Unitarians clearly had no equivalent rules or practices that could be used as the touchstone of validity for their marriages. Now, the idea of permitting ceremonies in licensed places of worship, first floated in 1823, was also regarded as problematic. My illustration here is not a pun on licensed premises. The George Inn in Plymouth was in fact one of the places where Catholics met in the early 19th century. The system of licensing of places of worship had its roots in suspicion of those who did not conform to the established church and a desire to know where exactly they were meeting. So any place where dissenters met for worship, however humble the building and however small the congregation, had to be licensed. With licensed places also including private houses and barns, there were obvious concerns about simply allowing couples to get married in such places, and the types of places in which non-Anglicans therefore might be able to get married. Even tightening up the provisions about which places of worship could be registered and who would be able to conduct the ceremony was not thought to offer sufficient security by itself. Now, concerns about delegating responsibilities to dissenters led to an alternative suggestion being put forward in 1827, that of allowing Unitarians to marry before a justice of the peace, mayor, or alderman. And this proposal reflected the view of many dissenters that marriage was, in fact, a civil contract. While this particular idea was not uncontroversial, it did enjoy a considerable measure of success. It got all the way to its third reading before falling at the final hurdle. And the idea of marriages being made in the presence of a representative of the state was to be a key element in the provisions of the Marriage Act 1836. Now, you had all these different proposals. You had some who wanted marriage to be a religious rite and some who saw it as a civil contract. But while dissenters were divided on whether and how marriage law should be reformed, they were united in their desire for a new system of civil registration of births and deaths, as well as marriages. And by the 1830s, it was increasingly clear that civil registration held the key for reform. Again, the question was, who would be responsible for this? One bill proposed tax collectors, which was seen as an indication of how poor the existing administrative machinery was. And another possibility that was floated was clerks of the peace. Now, the Marriage Bill 1836 proposed using the machinery of the new Poor Law. It created a new system of civil preliminaries, with notice being given to the superintendent registrar. Marriages were to take place in registered places of worship in the presence of a registrar, thereby combining the safeguards of both the 1823 bill and the 1827 bill. In other words, regulating both location and having a representative of the state present. Registrars would be responsible for ensuring that the marriage was registered, and for those who objected to getting married in a place of worship, there was the option of marrying in the office of the superintendent registrar. Now, most accounts of the 1836 Act suggest that the machinery of the new Poor Law was chosen because it was a new nationwide system. And it was certainly new. In fact, it was so new that it was not actually in force across the majority of the country. As of February 1836, only 228 unions had been formed under it in England and Wales. Around 100 more had been formed by the time the Marriage Act received royal assent. But even so, they accounted for only a third of the population of England and Wales. Moreover, the roles of superintendent registrar and registrars didn't actually exist under the new Poor Law. Clerks to the Poor Law Board of Guardians were to be given first refusal of the post of superintendent registrar, but the necessary army of registrars had to be recruited from scratch. So this raises the question as to why the government based this new system of civil registration and marriage on this very shaky basis. It seems clear that they wanted a pretext to press ahead with the implementation of the new Poor Law across the entirety of England and Wales. And the opposition that they met with indicated that there needed to be some pretext other than the unpopular Poor Law itself. Now, viewed as a matter of politics, the 1836 Act was masterly in simultaneously giving dissenters what they said they had wanted, an alternative to marrying in the Anglican Church, assuaging the concerns about clandestine marriages that had been voiced in relation to earlier measures, and advancing these other agendas. So it did ensure that no one would be compelled to marry in a way that was contrary to their conscience. Apart from the inclusion of certain prescribed words, there was no regulation of what form marriages should take. There was not even any explicit requirement that weddings in registered places of worship had to be celebrated with religious rites. Nor was there any prohibition on religious content being included in weddings in the office of the superintendent registrar. It was recognised that some highly religious couples might want to express their consent to marriage in a non-religious form, and that exactly what might be classified as religious might be a matter of debate. And there was no regulation of who should conduct the ceremony. It could be conducted by a priest or minister, or it could be conducted simply in the presence of the registrar. But from the petitions that continued to flood into Parliament, it was clear that the solution was not quite what many dissenters had wanted. Their request continued to be that the solemnization of marriages amongst dissenters may, at the option of the parties, be effected by their own ministers or by a civil magistrate. This suggested that for dissenters, the person conducting the ceremony was more important than the place. The Marriage Act also did enable the government to bring most parts of England and Wales under the auspices of the new Poor Law. But in some places, opposition was so great that attempts to implement it, and therefore implement the new legislation on civil marriage and registration, were halted. And in other places, unions could not be formed at all under the new Poor Law because of a pre-existing union. This inability to implement the new Poor Law everywhere necessitated various temporary expedients. One such expedient related to the publication of notices of marriage. The 1836 Act had stipulated that notices should be read before the weekly meetings of the relevant Board of Guardians, just as banns were read in church. For districts that had no such board, it was provided that notices could be posted in the office of the Superintendent Registrar, which at this stage, it should be noted, was not an institutional building, but simply the office of whoever happened to be Superintendent Registrar at the time, often a local solicitor. So overall, the 1836 Act was very far from being a coherent codification of the laws governing marriage. Anglican weddings continued to be governed by the 1823 Act, save that they could now be preceded by civil preliminaries and that copies of the register had to be submitted to the civil authorities. Quaker and Jewish weddings were somewhat clumsily brought within the scope of the 1836 Act, but only in that couples were required to give notice and a process was established for their marriages to be registered, with Jewish secretaries being certified by the Board of Deputies and Quaker registering officers by the recording clerk of the Society of Friends. Now, the take-up of the 1836 Act was just as diverse and complicated as the campaign for reform had been. Catholics were more likely to register their places of worship for marriage and to get married there than Protestant dissenters were. Few married in a register office, and those that did were very far from rejecting religion in doing so. We know from contemporary accounts that dissenting ministers were present at weddings in the register office, read passages from scripture, and led prayers for the couple. And this illustrates both the strength and the weakness of the 1836 Act. It was intended to be flexible, with no rigid distinction between religious and secular. But most couples who married in a register office in the early years would doubtless have preferred to have got married in their own place of worship, if they could have done so. That they married in a register office underlines how not everybody could get married in their own place of worship at this time. Now, the story of the reforms that were enacted in the 1850s is a far messier one, as the government reacted to a number of different problems that had arisen as a result of the 1836 Act. So the Places of Worship Act 1855 allowed non-Christian places of worship to be certified as such and so registered for marriages. At the time, its main significance was for synagogues that rejected the authority of the Board of Deputies. The West London Synagogue, which had been refused recognition by the Board of Deputies and whose members had therefore to get married in the register office, quickly availed themselves of this. The need for it to be registered, however, was removed the following year by the Marriage and Registration Act 1856, which allowed it to certify its own secretaries and those of any synagogues associated with it. The coherence of the 1836 Act was already beginning to unravel. The 1856 Act also amended the requirements for civil preliminaries. Dissenters had complained that the reading of notices of marriage before boards of guardians was insulting. In the absence of any other satisfactory solution, legislators fell back on the same temporary expedient that had been devised for districts without a board of guardians, that of displaying notices in the superintendent registrar's office. Significantly, no one attempted to suggest that this had worked well or that any advantage would accrue from adopting it more widely. It shows how easily an unsatisfactory stopgap can become a permanent fixture of the law. The 1836 Act also subtly recalibrated the roles of the state and the church in the making of marriage. The story here is quite a complicated one, but as it's important to a key change in the law, it's worth delving into a little of the detail. In 1856, prosecutions were brought against two Anglican clergymen who had both remarried couples who had married under the 1836 Act. So Lush had conducted a ceremony for a couple who'd been married in a registered place of worship, and Benson, depicted here, had done so for a couple who had married in a register office. And it does seem as if both the Registrar General and the Protestant dissenting deputies were on the lookout for a scapegoat. There had been issues about Anglican clergy not accepting the validity of marriages conducted under the 1836 Act. And these were sort of trial cases. So both Lush and Benson were prosecuted under the 1823 Act for conducting weddings without banns or license. Now, before they were tried, a clause was added to the 1856 bill, stating that couples could, if they so wished, have an additional religious ceremony after marrying before the registrar, but that would not supersede or invalidate any marriages previously contracted. Now, the phrasing of this is really significant. Marrying before the registrar obviously encompassed weddings in registered places of worship, as well as in register offices. The day after this clause was added, the Reverend Lush apologised and the prosecution against him was dropped. The clause was then amended so that it only applied to a religious ceremony being conducted after a wedding in the register office, which was what Benson had done. So this new clause explicitly permitted a religious ceremony after a register office wedding. But the implication was that it was not possible to have a second religious ceremony after a wedding in a registered place of worship. And following this, a further addition was made to the clause prohibiting the use of a religious service in the register office. Now, this made sense as a matter of logic. After all, it would be odd if a clergyman was prohibited from remarrying a couple who had married in a registered place of worship, but not where a couple had had a religious ceremony in a register office. But with a single stroke, this recast marriage in the register office as a purely secular right and removed the flexibility of the original Act. Now, the complexity of the religious and political background should not obscure the central point that this division between religious and secular, now seen as absolutely fundamental to the law of marriage, essentially came about by accident rather than design. There does not seem to have been any debate on it at all in Parliament or any thought given to its wider consequences. Benson, however, it should be noted, was acquitted. The judge held that since the couple were already married, he committed no offence in conducting a ceremony for them without banns or licence. You can't marry a couple who are already married, and therefore you can't be guilty of conducting a marriage ceremony without banns or licence in that context. Now, from the 1870s, there was a new campaign for reform. The inability of Catholic priests and nonconformist ministers to register the marriages that they conducted came under renewed scrutiny, with a campaign to dispense with the presence of the registrar at weddings in registered places of worship. The difficult question was who should replace the registrar. This was a point on which nonconformists were deeply divided. There were those, chiefly the Wesleyan Methodists, who prioritised equality with the established church. For them, the issue was one of status, and their ideal solution was for all their ministers to be automatically entitled to solemnised marriages, just as Anglican clergy were. But there were also those, primarily Baptists and Congregationalists, who rejected on theological grounds the idea of centralised control, had no ordained ministry, and saw legal recognition as tantamount to becoming agents of the state. In prioritising freedom, their preferences were as varied as their practices. Some were happy with the status quo. Some agreed with the Wesleyans that reform was necessary, but thought legal recognition of ministers should be optional. And some favoured a model of reform that would enable marriages to be conducted in their chapels without a registrar being present, but which did not depend on the authorisation of a specific minister. It was, in other words, something of a challenge to find a model that would work for all nonconformists, since none of these solutions would leave them both equal and free. There was also, it should be noted, quite a number who argued that parity should be achieved by requiring registrars to be present at all marriages, including Anglican ones, something that registrars themselves were quite keen on as well. But in addition to the question of who would be responsible for registering the marriage, there was the practical issue of how they would do so. So under the 1836 Act, registered places of worship had not been issued with their own register books. The registrar brought the official register with him and took it away again after the wedding. So in broad terms, proposals for reform adopted one of two strategies. One was to issue register books to specific authorised ministers who would conduct and register marriages. But of course, this was a problem for those denominations that did not have ministers. The other was to require the person officiating at the marriage, whoever this might be, to complete certain prescribed documents confirming that the marriage had taken place and return it to the superintendent registrar. While this neatly sidestepped the question of the status of the person officiating and obviated the need for new register books to be issued, the risk was that it left marriages entirely unregulated. The solution proposed in what became the Marriage Act 1898 was that each nonconformist church should be issued with its own register book once a person had been authorised to take responsibility for the custody of that register, the registration of marriages, and the making of returns. Authorisation would be the responsibility of the governing body of the registered building. Now, the new terminology of authorised person seemed a graceful compromise between the competing concepts of authorised minister and person officiating. However, amid the flurry of minor textual amendments made to the bill during its final stages in the House of Commons, there was one in particular that fundamentally changed what it meant to be authorised. The original bill had referred to an authorised person officiating at or solemnising a wedding. The textual amendments of the third reading removed those words, making the role of the authorised person essentially a passive one. They would simply had to be present and register the marriage. And the form of the new register books emphasised that authorisation was not an acknowledgement of the status of non-Anglican ministers, but simply permission to act as a replacement registrar. The printed phrase, "in the presence of," implied that they were no more than witnesses. When combined with the very cumbersome regulations issued by the Registrar General and the threateningly vague provision that a failure to comply with any of these regulations or any other requirement under the Act would constitute an offence, the role was not a particularly attractive one. In the wake of the 1898 Act, most weddings in registered buildings continued to take place before a registrar, and the 1898 Act was regarded as neither a satisfactory nor a final resolution of the issues. Indeed, one new division had been introduced. While any certified place of worship could be registered for marriage, only places of worship that could have been registered under the 1836 Act, i.e. only Christian ones, could appoint an authorised person under the 1898 Act. Now, that particular limitation was to acquire particular significance for a new strand of liberal Judaism that emerged in the early 20th century. The existing exemption for Jewish marriages assumed authorisation either by the Board of Deputies or the West London Synagogue. Liberal Jewish synagogues could be registered for weddings, but they had to accept the presence of the registrar and the other constraints that went with marrying in a registered place of worship. And so too did those marrying at the mosque in Woking when it was registered for weddings in 1920. So moving into the 20th century, a brief perusal of the statute book might suggest that nothing much changed in the 50 years after the 1898 Act. But it is worth noting the escalating complexity of the law. The Church of England's power to pass measures meant that numerous changes to the law governing its weddings were made, causing them to diverge both from the statute and from the laws applicable to the newly disestablished church in Wales. It's also worth noting the mistakes and misunderstandings that resulted in Parliament having to pass a considerable number of validating orders, including, somewhat ironically, to the legislation actually governing the passage of validating orders. They belatedly realised that the clause that they thought was in the validating legislation wasn't in the validating legislation and had to pass a new act to allow them to pass the orders. Of the 46 orders made validating marriages between 1920 and 1949, 28 involved questions about the status of Anglican churches. There were churches that had once been the parish church, but which had been replaced by a new church within the same parish, new churches that had been consecrated, but not formally substituted for the existing parish church, and churches that had been built in addition to the parish church. In the case of St John's Shotley in Northumberland, the realisation of the necessity of the church being licensed as well as consecrated seems to have been particularly belated. The church was finally licensed for weddings on the 11th of November 1936, having initially been consecrated on the 30th of August 1837. 1838 also saw an order validating marriages conducted by a Methodist minister who had not been authorised, possibly the inspiration for J.B. Priestley's play, When We Are Married. The picture there is from the first production of it, which was first performed later that year. In the light of the number of changes made during this period and how they'd been affected, weddings law was an obvious candidate for the new process of consolidating legislation. The schedule to the resulting Marriage Act 1949 listed no fewer than 38 enactments covering a period of over 400 years that it had repealed either in whole or in part. Yet while bringing all of these provisions together made the law more accessible, it did not necessarily make it any more coherent. The new Act clarified certain points, but obscured others, failed to resolve some long-standing ambiguities, and did nothing to address some of the controversies that had arisen in previous decades. So looking at the structure of the 1949 Act, it's hard to escape the suspicion that reformers simply started with the oldest statute governing marriage and worked forward from there. Far from improving the manner in which the law was stated, this chronologically inspired structure perhaps served to overemphasize the divisions between Anglican and other marriages. The heading of Part 2 referred to a religious rite, weddings in the Church of England, that of Part 3 to authorization by a civil official, marriages on the basis of a superintendent, registrar's certificate or license. The new structure also continued to obscure how tightly regulated Quaker and Jewish marriages actually were, although it did at least clarify that they were subject to the same annulling provisions as applied to marriages in registered places of worship or register offices, which had previously been a matter of debate. Those casting their eye down the list of headings in the statute might well have concluded that such weddings were almost entirely free from regulation. The single section heading, Marriages According to Usages of Society of Friends, merely set out who could marry in a Quaker ceremony. And the complex rules as to who was required to certify those who could register Quaker and Jewish marriages, which revealed the structures within which such marriages were to take place, appeared under the unilluminating heading, Interpretation of Part 4. Now, the joint committee that was set up to consider the draft bill interpreted their powers narrowly, but one existing anomaly did disappear as a result of drafting. During the course of discussions about whether liberal Jews should be put in the same position as Orthodox and Reform Jews, the Joint Committee became aware that liberal synagogues could not appoint their own authorised persons under the Marriage Act 1898. The GRO argued that the removal of this particular anomaly was of sufficient importance to require separate legislation rather than being revised as part of the process of consolidation. It would, however, have been difficult to continue this anomaly without openly discriminating against non-Christian groups. There was no longer any justification for making the right to appoint an authorised person contingent on whether a particular place of worship could have been registered for marriages under the 1836 Act, since this Act was about to be abolished. As a result, this particular piece of discrimination against non-Christian religions was abolished by default. In legal terms, surprisingly little has changed since 1949. There have been a number of minor changes. Liberal Jews finally acquired the same status as Reform Jews in terms of certifying their secretaries. The preconditions for places of worship to be registered have been modified. Sharing arrangements enabled Anglicans and other denominations to celebrate weddings in the same building. And the Registrar General's licence provided an alternative to the Anglican special licence for deathbed weddings. How couples have married has changed more radically. Parity between religious and civil weddings was first achieved in the 1970s, and the balance between the two shifted more dramatically after the Marriage Act 1994 introduced the possibility of marrying on approved premises. But the number who are having a separate ceremony with some religious element suggests that we should not see this trend of marrying on approved premises as a wholesale rejection of religion or embracing of civil marriage. It can also be seen as indicative of some of the obstacles in the way of getting married according to religious rites, just as it was for many of those getting married in the first register office weddings. Now, the problems with the current law and how these might be addressed are going to be fully covered in Nick's talk. So there's just 3 points that I want to reiterate by way of conclusion. First, many of the problems with the current law are of long standing. Religious-only weddings are nothing new and nor are they confined to any one religious tradition. Even when the 1836 Act was enacted, it did not fit with how many couples wanted to marry, or enable them to marry according to their own religious rites. And this was exacerbated by the change that was made in 1856. Secondly, the longevity of a particular requirement does not always mean that it was introduced for a good reason or that it has worked well. Many of the current requirements have their origins in past panics, political expediency, tactical compromises, or quick fixes. And third, this is what Mark referred to in his sort of opening remarks, none of the reforms to date have really addressed weddings law as a whole. So I think we need to recognise the limitations of earlier legislative interventions. The 1836 Act added options rather than creating a coherent new law. The 1856 Act was a quick fix political response to a collection of specific issues that had emerged. And the 1898 Act was a single issue reform that didn't even really address the single issue that reformers had been campaigning for. The 1949 Act simply consolidated all of the complexities of the law into a single statute. And therein lies the reasons why the current law of marriage is uncertain, complex, inconsistent, and in need of reform. Thank you for listening, and I'm very happy to take any questions.
Well, Rebecca, thank you very much indeed for giving us that masterly exposition of the past and of how marriage law has developed. And I think also, certainly for me at least, for exploding some of the misconceptions and assumptions we make as to what the past law was and what were the features which introduced it. Forgive me when I say exploding those presumptions. I'm well aware when we were speaking offline earlier that you live perilously close to that World War II munition that went off a week or so ago at Exeter. So we're glad you were spared to give your lecture this morning. Rebecca, you kindly given time for questions. There aren't a huge number that have appeared in the chat box during the course of your presentation. And I'm also inviting people, if they want to come with questions now, to raise their hands if they would prefer. I know Frank Cranmer quite early on had a question, and I'd be happy to go over to him if he'd like to put it. It means tearing himself away from his Twitter feed for a moment. But Frank, would you like to put your question while I try and scoop together some others?
Yes, Rebecca. Going back to the beginning, when non-Anglican clergy, when non-Anglicans were permitted to marry other than in the parish church, was there any element of relieving Anglican clergy from the duty of marrying people that they knew perfectly well didn't actually believe in Anglican doctrine, or was that not considered?
That was very much considered, and there was quite a lot of support within the Anglican Church for giving dissenters an alternative for that reason. So you had on occasion Unitarians publicly protesting in the service against having to say the Trinity, which obviously made things very uncomfortable for everyone. And you had the Archbishop of Canterbury saying, actually, it might be preferable rather than us conducting these services where we know that they don't believe what they're saying, that there should be some alternative. So yes, that was very much an important element.
Thanks.
I think people are still being a little bit shy and reticent, but there's a question from Olga Pierce, which we'll take next, and then I'll go to James Berrend. So, Olga.
Thank you. Yes, Rebecca, My question goes back to the very early part of your talk, and in fact, slightly before it, because it's to do with the relationship between the 1836 Act and the 1823 Act. It seems to me that if you leave Jews, Quakers, royalty to one side, the 1823 Act did actually try to address weddings law as a whole, because it applied to all weddings in England. And the 1836 Act applied, for example, in section 42, its provision in what was void, to weddings under this Act. In other words, it was not comprehensive, it was an exception to the 1823 rules. Now, what, in your view, enabled a ceremony to be identified as a wedding under the 1836 Act? Because if it wasn't one, you obviously had to go back to 1823.
So the courts have generally interpreted that as some kind of engagement with the terms of the 1836 Act. But as I said, towards the end of my talk, religious-only marriages are nothing new. So you have always had issues where a couple may have been married by a Catholic priest, but they haven't got married in a registered place of worship, and the Catholic priest, before 1898, wasn't an issue anyway that they could be authorised. And those ceremonies have been seen as falling outside the 1836 Act, and obviously fall outside the scope of the 1823 Act as well. So yes, you could see both the 1853 and the 1823 ones as attempting to codify marriage law, but of course they're only really legislating for Anglicans. And although they're exempting Jews and Quakers, they're not even saying what the status of their marriages are or how they're to be regulated. Yes.
If I can very quickly come back, I quite agree that such ceremonies before 1949 actually changes the goalpost to my mind, but before that, I would agree they fell outside 1836. I would not agree, whatever religious tradition is involved, that they fell outside 1823, because the 1823 rules applied to everybody, except the three classes.
I don't think the result would change, though, because they would be void as...
They would be void, yes.
So, yes.
They would be void, but there would be no basis for the concept of non-marriage. Okay, enough. Thank you very much.
I'm going to go now to James Behrens, please, and then I'll follow that with Paul Hutchinson. James.
When I was at university in the 1970s, my director of studies suggested that all marriages should be entirely civil, and once they had been completed, the parties should be free to do whatever religious ceremonies they liked. I didn't agree, but I'm not sure that I could put my reasons as cogently as you have in your summary today. But do you think all marriages should be civil?
Personally, no, I don't think all marriages should be civil. If you look at those countries that have introduced universal civil marriage, they've generally done so for very political, ideological reasons. They have a particular view about the relationship between the individual and the state. And universal civil marriage has often been a sort of a deliberate tactic to break the power of the church. So revolutionary France, revolutionary Russia, quite a number of Spanish countries of the 19th century rejecting the Catholic Church. And this argument about universal civil marriage does sort of come back again and again in terms of, well, it makes things simple, it makes things convenient. I don't think it makes things simple because it means that anybody necessarily has to arrange that separately. If they have that before, in line with their religious conscience, then you have exactly the same problems that you have with religious-only marriages at present, for the risk of a gap between the religious ceremony and the legal recognition of it. And it takes away it takes away choices. I mean, I think there should be the option of civil marriage for those who want it, but I don't see why that should be a requirement for those who want it to be solemnized in a religious ceremony.
Yeah. Thank you.
What I propose doing now is to take together two short questions from Paul Hutchinson and David Pollock, respectively. And then when Rebecca has answered those, return for what I think will be the final question. It's a slightly longer one, and that will come from Ian Blaney. But can we take Paul Hutchinson first and then immediately David Pollock? Paul.
Not all of us here are great ecclesiastical historians, and there is a sense in which everything you've told us is a footnote to the 1753 Act. Is it possible for you very quickly just to outline the things that brought the 1753 Act to light, the kind of main features of life before 1753, in other words?
Thank you.
Can we go straight to David as well to put his question? And then Rebecca, I'm sorry, I'm going to ask you to answer them both together. Yeah. David.
Mine is not connected at all with the previous question. Simply, was there any recognition at the time of the 1949 Act that mere consolidation was not a very satisfactory move?
Two short questions. I expect a slightly longer answer, so I'm sorry, Rebecca.
Yes. So the second is probably more speedily answered, in that marriage law had long been recognised as in need of far more than consolidating reform. And as I say, you can see why they thought it needed consolidating, but I'm still baffled as to why they didn't undertake a sort of more radical reform of it back then. On the 1753 Act, there had been the long sort of title of the Act is an Act for the better preventing of clandestine marriages, and there had been concerns that ordained clergymen were essentially not complying with the requirements of the canon law. They were conducting marriages without banns or license, or any formalities, and there was a particular concern about clergymen operating outside or the rules of the Fleet Prison in London beyond ecclesiastical authority, to the extent that by the 1740s, over half of all marriages in London were taking place in the Fleet, and marriages were essentially becoming out of control. So you had lots of entirely inappropriate marriages taking place as a result of no questions being asked. You had bigamous marriages, you had underage marriages, you had every sort of inappropriate marriage you could think of, and that was why the 1753 Act was passed.
Splendid. And I think for what will be the final question of this session, it's quite long, Ian, we may want to summarise it, but I go across to Ian Blaney.
Yes, well, my question follows on really from this question about Hardwicke's Marriage Act, and I want to cast us back to the acrimony of the pre-1753 and around the 1753 situation, where there were cases around whether the canons of the Church of England could be enforced against the laity, and there was this famous case of Middleton against Crofts, where it was decided actually the canons only bind the laity where it's declaratory of pre-Reformation law, and we try that case again, I think probably wouldn't even get that. And in the proposals that the Law Commission have put forward, they have this idea that, well, the Church of England will be in a similar position as all the other religious groups. There'll be some statutory rules, and then the individual religious groups can make their own internal laws if they want, but they're not be enforceable in statute. I just wonder whether this will go back to the uncertainty and confusion of that time before Hardwicke's Marriage Act. If you've got a bleeding heart member of the clergy who agrees to solemnize a marriage in a churchyard where the bride wants to get married next to the grave of her late father, or agrees to marry them at home because he's a bit confused with the new system, you've got a situation there where he's breached the canon law, but not necessarily the statute law. So what happens?
So I don't want to obviously speak about how the sort of church might discipline its own members. I'd see that as an internal matter. But certainly in terms of the Law Commission proposals that Nick will be talking on shortly, I think one crucial difference between those and the pre-1753 law is the much tighter structure within which marriages would be taking place. So notice and registration would be required and enforced much more stringently than before 1753. Before 1753, if you didn't have banns or license, your marriage might be clandestine, it would be in breach of the canon law, but it would still be valid as long as the wedding was conducted by an Anglican clergyman. Whereas the key point in the Law Commission's proposals is that actually a marriage that's not preceded by the appropriate preliminaries, whether those be civil or Anglican, it would actually be void. So it's very much enforcing those requirements, the sort of pre-existing checks as to whether the couples are free and willing to get married.
Rebecca, thank you very much indeed. Having said how rigorously we will stick to time, I'm going to make no apology whatever for going over time, because I took some of your time in my words of introduction. So, but no doubt the later moderators will be more rigorous than I have been. There are a couple of observations in the chat box, and what I suggest is that we could come back to those at the panel discussion at the end of the day, and I'm very grateful to you and to all speakers that they've agreed to be part of that panel discussion. But one contributor has asked for further reading, and one of our team has already placed in the chat box your own forthcoming book, which appears on the outline for today. I wonder whether during the course of today, Rebecca, you could add to the chat box your recommendations of further reading, and please avoid false modesty and feel entirely free to include your own works amongst those. We've got off to a stonking good start this morning. We have a break now until 11:30, when Nick Hopkins will take up the running, going from history to very much the present day. But can I, on behalf of everyone who's listened with rapt attention and gratitude, thank you, Rebecca, very much indeed for this first lecture today and for getting us off to such a very good start. Thank you very much indeed.
Thank you.